So welcome to Straight Talking Law. I'm Abby Washbourne, Solicitor and Director of the Criminal and Family Departments here at Kidwells, and I'm with...
Michael Horn, who's a Solicitor and Director here as well with you, Abby.
And we're talking today, aren't we, about the landmark decision of Standish and really the consequences that it's had across family law, just generally, really. And some people have called it the £78 million question, which I think is quite a catchy little reminder, I think, of the sheer wealth that was involved in that case. But actually, it's a landmark ruling, and the court has really shaken up how non-marital assets are treated in divorce, really challenging long-held assumptions about inherited wealth, trust, and financial autonomy in high net worth relationships. And the high net worth relationship aspect of it is important because, of course, it doesn't mean that the court can't take into account non-marital assets when it comes to meeting parties' needs.
Let's first of all say this word. It's going to be quite difficult to say now, but it's going to be appearing in family courts, financial settlements, and that's matrimonialized.
Yeah.
So matrimonialized. And what does that mean? That's the question, really. And that is, when does an asset that's owned by either party prior to the marriage become an asset of the marriage itself? So it's like a change in ownership of that asset. It could be wealth, it could be an asset per se. So when is something matrimonialized? And I think the law previously hasn't changed, even though we're all of us going to be jumping on the case of Standish, and we're going to be saying, well, it has changed. And I don't think and you and I were going to talk about this today, but when we actually dig down into the root of what the law is and the power of the courts, the discretion within the courts, it's still only another little bit of assistance for the courts to follow, but it gives some scope. And when we're looking at that, I think the first place to start is America, and let's have a talk about what might be a prenuptial agreement in America. So we know what one of those is, Abby.
Yeah, so I think you're right. The law hasn't changed, but perhaps this case has just clarified some issues which are significant. And when we talk about America, our understanding of America, and I'm not giving advice, as an American lawyer, because I certainly I'm not one, but our understanding just generally, I think, is that they are really taken into account. A prenuptial agreement is a contract that's enforced by the court should you divorce, and actually it's not quite the same here, is it?
No. So the court has got, so that I think that's absolutely right, Nate. And I'm not an American lawyer either, but we hear about these big settlements of extremely wealthy people, usually the stars. They're either actors or singers or somewhere like that, and they've got this massive amount of wealth, and somebody comes into the relationship with a few dollars and they marry this person with billions of dollars, and the question is whether or not they only leave the relationship with their $2 that they came in with. That isn't the case here. So the courts have always had the discretion and still have the discretion to say, what did you bring to the marriage? What was the marriage at that time? And then the timeline then starts to count. People that have prenuptial agreements might think, well, I own this particular asset, this amount of wealth, and I want that to be mine in the event that we divorce. And they spend money on one of these prenuptials, so before you get married, agreements, and they're not enforceable per se.
Yeah, for example, if it was a house, a property perhaps that they wanted to ring fence, if actually years down the line they've been treating it as the matrimonial home, then perhaps the courts wouldn't really give as much weight to that prenuptial agreement that tried to ring fence that property because it's become matrimonialized.
Yeah, well done. You said that extremely well. So, and that's absolutely right, isn't it? So it's more about time, I think. If you're getting married now in the immediate near future, and you come into this marriage with considerable assets, and you have a prenuptial agreement to say those are my assets, and 13 months down the road you end up getting divorced, then there's a strong persuasion for the court to say, well, those assets belong to that person before the marriage. You agreed to that by when you took the independent legal advice on your prenuptial agreement. So why shouldn't those assets remain the property of that person? And therefore they've not been matrimonialized. They've not been merged into the marriage. But as you progress in life, in your relationship, and you are together for 2 years, 3 years, you have children perhaps, and the relationship is reliant in that one person stays at home, possibly looks after the children and supports the other, who then goes out to work, and together you generate this wealth that you use the basis of that one person's wealth to do. Then there's a very, very strong assertion from the court that all of those assets are matrimonialized. They are all of them together. It's important when you look at this that these cases, such as Standish, we're talking about the tens and 20, 30, 40, 100 million pound settlements.
Yeah.
The kind of case law that normally we come across are just normal people.
Yeah, normal people. There might be some wealthier people, but actually it's not to the level of the 20, 30, 40 million pounds. And I think the important thing is some people, again, I think a little bit carried away with this judgment in the changes that they say have been made. But actually, if it's the case that, there's only enough assets there in order to meet the needs of the parties, then the courts will still look at those assets that haven't been matrimonialized yet. In order to meet those needs. It comes down to the sharing principle, which is different.
Yes, and which is overarching. It's got that the court has got the use of that when applying its discretion. So in the Standish case, I noticed that some money was transferred from one to the other with a view to some tax planning. And the court has specifically mentioned that in this case.
Yeah, I think some people will assume that if some property has been transferred into your name or your joint names, that that's enough to demonstrate that it's been matrimonialized. But this case demonstrates that that's not the case at all. It's about the purpose, isn't it? And the way it's actually been treated. Has it been treated with a view of sharing it? Have you both shared it at any stage? Has it been a major part of your marriage? But in this case, it wasn't. It was just for those tax purposes, wasn't it?
Yeah, so a paperwork exercise.
Yeah,
really.
So it hadn't really been sufficiently matrimonialized in order for it to be shared on that basis.
Yeah.
And it's complicated. There's no hard and fast rules that mean that there's a guarantee that, one party will only get this or that. Actually, the court assess it on a case-by-case basis, and they have a lot of discretion, which they still retain.
So in your opinion, is it still wise to get a prenuptial agreement if you're coming into a relationship with wealth?
Absolutely. And it may be, as we talk about those kind of times, and if the longer that you're married, the less weight that may be attached to it, you could have it reviewed perhaps every 5 years, which would be a good idea as things change in your relationship, maybe as you start to have children, you start a family. And in order then to demonstrate that should you divorce, actually that this was your intentions, this agreement is in line with both parties' intentions only a couple of years ago, and therefore it should be taken into account. And an agreement that's entered into post-marriage can be called a post-nuptial agreement. So it may well be that there's a prenuptial agreement in the first instance, then after 5 years it's reviewed and a post-nuptial agreement's drafted, and then maybe every few years thereafter it's reviewed. Even if it doesn't change, but it's reviewed and it's dated, it will show to the court that these are your fresh intentions.
Yeah, and as people are getting wealthier, there's a lot more wealth out there in society. So there's this question, which is going to be the Standish question, is going to come up more often. And so if you've got a good prenuptial agreement and you have then postnuptial revisits of that agreement, then that is going to possibly, as the case law develops, as time moves on, those documents are going to have more and more and more weight. But again, that overarching principle of fairness is really going to be on the court's mind, especially if somebody's become accustomed to living in a certain way at a certain standard. Children are involved, possibly private education. All of those things need to be maintained, and a court will have less of a mind to look at a pre or a post-nuptial agreement when considering which share of the matrimonialized assets go where.
And it's important to note also that there are strict rules on how a prenuptial or postnuptial agreement must be drafted in order to maximise its enforceability. And those rules were set down by the case of Brad Macho and Granatino some years ago. And it's quite important that it's drafted specifically in line with those rules, because otherwise, if it's not, then it almost certainly won't be enforced later. And that agreement mustn't be significantly unfair, for example. It must meet the parties' needs. Each party must have actually obtained independent legal advice to ensure that they both know what they're entering into. There must be sufficient financial disclosure, etc. And so those are just some of the rules, but it's important that you instruct a solicitor that you can trust is going to handle it appropriately. So should you unfortunately have to rely on this agreement, then it will be enforced, or a significant portion of it will be enforced.
Yeah, those points are absolutely valid. If you have one and you want to get it checked, then you can bring it to us.
Absolutely. Yeah, and we will assist fully.
Yeah, and we'll make sure it's there, and we'll also do the post-nuptial updates of them. If that's a requirement, we can do that.
Definitely, and we're well versed in divorce law because we specialise in it. So actually, it makes us quite good to look at these kind of agreements because we understand how the courts are currently operating and how they're viewing different things in the case law. And so please come along, bring your agreement, or at least bring your instructions for an agreement, and we'll fully assist you.
I was giving some advice recently to somebody who came to us for advice on assets and said, look, well, this is mine, but it's not in my name at the moment. But honestly, whoa, stop there. A prenuptial and postnuptial agreements have got to be based on an honest disclosure of the assets. If in any way you've not been honest about it, then you can expect the court to simply say, I'm not going to trust what you say, and move forwards in dealing with the matter as that judge would deem fit and fair.
Exactly, that means disclosing all of the assets. For example, if you withhold a significant pension, you don't disclose that as part of the pre or post-nuptial agreement, then the court might think that you've tried to mislead the other party slightly, and perhaps they haven't entered into the agreement with full knowledge.
Yeah. I often talk to people about equity, and people don't understand equity. And so equity isn't the amount of value that you have in your home or your business or your car. Equity is about fairness. And if you want the court to exercise its discretion in your favour, even when looking at a pre or a post-nup, then they're going to be saying, is this fair? And if you've been deceitful in any way to your partner, then the court's just likely to say it's not fair, and that document will go in the bin.
And on the subject of fairness, something that we frequently say to clients actually is, and remind them, is perhaps what they deem to be fair isn't exactly what the courts would deem to be fair, and they might be a little bit disappointed. So a pre or post-nuptial agreement might manage expectations a bit better, and actually if it will be enforced, or at least largely enforced, then it might be more in line with what they understand to be fair.
Good. Abby, again, I love speaking with you about these things. We work quite close in the building here together, but we talk all of the time about our cases. So I know how you progress yours. You're a very safe pair of hands. Anybody got any issues for anything to do with matrimonial law, child contact, a different subject for another day. Financial separations, definitely the subject matter really of Standish. Then come and give you a call.
Yeah, thank you, Michael. And Yeah, definitely. Come and give us a call, make a new inquiry through our website, whichever suits you, and we'll assist you fully.
Good. Thanks, Abby.
I think that's it for today's episode of Straight Talking Law. The Standish and Standish ruling does mark a significant shift in how the courts view wealth, marriage, and fairness, especially when big money and family trusts are involved. Whether you're in the legal profession or just want to understand how the law affects your life, we'll keep bringing you the clarity that you need. If you have found this episode helpful, don't forget to subscribe and share it with someone who'd benefit from listening. Thank you.